Hello, and welcome to the ATPE Podcast, brought to you by the Association of Texas Professional Educators and covering the hottest topics on Texas educators' minds today.
Hello, and welcome to the ATPE Podcast. My name is David George, and I serve as the ATPE News Magazine editor. Today, we're going to be discussing associate members, specifically your rights and what you're entitled to under both state and federal law. We're joined today by Lance Cain, an attorney in the ATPE Member Legal Services Department for the past 17 years. For a little background, he spent the first 10 of those years as an on-call attorney, taking calls daily from ATPE members. In the last 7 years, he has been a travel and grievance attorney, providing our members with support and on-site assistance. We're really happy to have you return to the podcast, Lance.
Thank you, David. It's good to be here this morning.
So let's start with what is or who is an associate member?
Yeah, all right. So school districts have a lot of different types of employees. And so our membership department has broken them down into different categories. And one of those categories is an associate member. And those would be bus drivers, front office staff like secretaries and clerks, in-class support like instructional aides, paraprofessionals, groundskeepers, maintenance workers, cafeteria workers, all the types of employees that really form the foundation of a school district and make it run smoothly and efficiently. So they really do an important job. So I think it is important to talk about kind of what rights they do have and also what rights they don't have. Texas is an at-will state. So if you do not have a contract, that means that you can be terminated for any reason or no reason at all. And also on the flip side of that, you are allowed to resign without any kind of notice. And so I think there's a little bit more flexibility, but also there are some specific rights that are important to kind of go into.
So let's begin with pay. What can you tell us about overtime, comp time, district compensation plans?
Yeah, so unlike a teacher whose pay would be governed by the Texas Education Code, where there's a sort of minimum salary scale that's put out and it sort of ranks them by years of experience. There's nothing like that for, say, a food service worker or a janitor. They are really kind of at the discretion of the district's compensation plan, which means that there's a lot of flexibility that district has to categorize and set sort of different levels of pay. A lot of times it'll be a range. There is a floor to that, though. There's the minimum wage laws, and so a district cannot pay an employee less than $7.25 an hour. One of the major differences, though, in how a teacher would be paid versus how an associate member would be paid are the overtime laws. That is a very strong law that associate members have. It's through the Fair Labor Standards Act, which is a federal law. And overtime itself is a pretty complicated analysis. It's really, you have to look at what the employee does and the duties, the specific duties. So that in itself could form the topic of an entire different discussion. But for the purposes of today, I'm going to break it down between sort of exempt employees, meaning that they're exempt from overtime, and then non-exempt employees, meaning that they do get overtime. The exempt employees are going to be like teachers and principals. So if they worked 50 hours this week, 30 hours next week, and then 80 hours the following week, their pay would be the same. They would have the same salary. If the same thing happened to an associate member, they would be entitled to overtime in those circumstances. So the non-exempt employees are entitled to overtime and would be getting time and a half, which is 1.5 times what their salary is. It's not actually per day. So it's not like if an employee works 10 hours in one day, they will get 2 hours overtime. It's judged on a 40-hour work week. So a lot of districts will have internal controls on how they deal with that. So if a clerk or something works 9 hours in one day, they might be told, let's work 7 hours the next day to kind of even it out through the week. But it is very important for those employees to keep track of their hours. Districts might have a clock in and clock out system, but if they do not, it's a good idea for the employees to log their own time. And also to kind of be aware of what the district's overtime policies are, because a lot of districts will have a requirement that there is some type of approval before they work overtime. That's important because if they do not get approval and accidentally work overtime or even intentionally work overtime, they're entitled to the pay, but they can be disciplined for working the overtime without having that permission. So they could be terminated or given a reprimand. So it is a good idea to be aware of what those policies are of your district. Look at employee handbook or ask your supervisor because there could be even a mistake could result in some type of discipline to the employee. And then one specific thing that can come up is instead of paying overtime, the district can offer comp time. So it would be, say, time and a half on a paid leave day. So if an employee works 1 hour of overtime, they'd be entitled to 1.5 hours of comp time. So some districts do it like that. Some districts will actually pay, and some districts don't really approve much overtime at all. It really kind of depends on what the employee's job entails and kind of what the district's staffing situation is. One thing that has come up in Texas because of how big of a state it is, we have times where there might be a hurricane or there might be some bad weather. And so our associate members will ask, do I have to get paid during that time that the district is closed for a week or two? The law actually does not require the districts to pay the employees that are not working during that time. Unless they have sort of a contract. So a teacher, there'd be a different analysis for that. With a associate member, they can be paid, and we did see a lot of that happen during COVID and some of the other weather-related closures, where a school board, went before they had a meeting and they made a proposal, and if they find that there's a public purpose for paying the employee, they can identify how long the pay is going to be, and they can identify what types of employees are going to be getting the pay. So a school district can approve pay during that time, but it's not required by law.
What about associate member duties, job description, assignments, reassignments?
Yeah, that is one of the major differences between associate members and other types of district employees that might have a contract. The contract will outline many of the rights that a teacher has, for example, and will also sometimes outline their specific title. Without that, the district has a lot of flexibility to make assignments and reassignments and even change assignments that the employee might have. And so an employee, we get the question a lot from associate members, well, this was the job that I was hired for, or this was the school that I was hired at. And actually, the job is with the school district. So the school district would have the right to reassign them really to any place within the school district, and also would be able to change their duties and even in certain situations make changes to their working hours. Now there would be some overtime protection there. And then the question comes up a lot, what about my job description? Because people will say, well, this has my title on it, or this has my pay or pay scale, or this has my duties. And actually, a job description is more of a guideline. It's not a binding legal contract. So it's helpful in kind of telling you what the expectations of the job are, but it's not a document that you can use to force the district to keep you in that position. And so really, there's a lot more flexibility with duties, and school districts can have reassignments pretty much to almost any position for an associate member.
Are associate members entitled to lunch and other breaks?
Yeah, that is a good question. I think many districts offer those. It's sort of just a standard practice because doing a job for 8 hours in a row can be difficult. So best practices would be to give breaks and give lunch. Federal law actually does not require any kind of lunch or coffee break. There is some limitation though that if they are provided, so if you do get a coffee break or a short break, 5, 10, 20 minutes, then that is counted as compensable time. So you're not required to clock out. It's counted towards your workday. It's counted towards overtime, and you get paid for that time. There is an exception if you are a new mother taking a break to express milk. Then that can be unpaid. And so there are some laws that require employers to allow new mothers to do that. But that would be the one exception where they can actually not pay them for that time. With the lunch, there's actually not a requirement of lunch either. So federal law and state law do not require lunches for associate members. The thing with lunch is because it's a little bit of a longer break, a school district can require them to clock out during that time and not pay them. So it's not the same as a short break, and they can actually not pay them during their lunch.
For those associate members working in a district of innovation, what sort of impact could that have?
Yeah, actually, because districts of innovation are aimed towards state law, they're aimed towards the Texas Education Code, and a lot of the Texas Education Code gives rights to teachers. If a school district is exempting themselves from those types of employee rights that teachers have, it will have actually less of an effect on an associate member. So, I mean, we're talking things like the duty-free lunch, that's for teachers, conference time for teachers, even class size. So a school district could take those rights away from teachers through a district of innovation, but really wouldn't be as affecting a associate member as much. So districts of innovation, it really depends on the specific plan, but in a lot of ways, associate members have kind of escaped that situation.
Talk to us about associate member rights under federal law.
Federal law is one of the big parts of where associate members kind of have some of those rights. The FSLA, the Fair Labor Standards Act, is what governs overtime. So that is one of the major rights that associate members have. And then there's also a bunch of federal rights that most employees have. So whether you're a teacher or whether you're an associate member or us, for example, FMLA, the Family Medical Leave Act, so that entitles employees to take up to 12 weeks off if they have a serious medical condition to care for themselves or even to care for a close family member. There are some eligibility requirements, so the school district has to have at least 50 members, and also the employee has to have been there for the previous year and worked 1,250 hours. But the FMLA is a really good leave act because it allows school districts or it allows the employees to take time off without having to worry about getting terminated. Their job is waiting for them when they come back, or at least a similar job. So it is a really good protection that associate members have. The Americans with Disabilities Act is another good law. It's a federal law that associate members are entitled to. That allows employees with a disability to request accommodations from their school district to allow them to do their job. So associate members have the same rights from under the ADA that any other employee would. And then also the federal discrimination laws. So you cannot be discriminated against or harassed based on your membership in a protected class. And those apply to the associate members as well.
And their rights under state laws regarding workers' comp, temporary disability, and so on?
Yeah, there are some rights under state law that do apply to the associate members. You mentioned the state leave. They are entitled to 5 days of state paid leave under state law. Assault leave is another one that applies to all employees at a school district. So if you are working and you get assaulted at school and have to take time off for physical injuries, that is on the school district, so you do not have to use your own paid leave for that. Workers' comp as well. We don't do workers' comp in the legal department, but that's something that comes up if you are injured at work, and not necessarily an assault, but if you're injured at work, you're entitled to compensation benefits for that. Temporary disability leave might apply to an associate member if they're in a position that requires a certificate, so like an instructional aid. And what temporary disability is sort of a state version of the FMLA. So it's a extended leave that has job protection in it. It allows employees to take up to 180 days off. And it's only for the employee, so there's a little bit of difference between the FMLA. So it's only for the employee and not for any family member. But that is a good way for if an employee has a serious medical condition that they can take time off without having to worry about losing their job.
In the case of unpaid admin leave, termination without due process, those under investigation, what do associate members need to know?
Yeah, the differences are pretty wide in that area. So if there's an allegation or some type of investigation based on workplace conduct, then unlike a teacher with a contract, they typically have to be placed on paid administrative leave because of the contract. And with an at-will employee or with an associate member, because there's no contract governing that pay, they can be placed on unpaid administrative leave while the district performs the investigation. Some districts will pay them anyway, so it's not like it's required that they are unpaid. So some districts will pay even though they don't have to. But it is something to be aware of, that if you are under investigation, you can actually be placed on unpaid administrative leave. Terminations as well, because of the contract, teacher contracts and the Texas Education Code require due process, and they require a good cause to terminate a teacher during the middle of their contract. Because of the at-will doctrine, employees that do not have a contract, associate members, for example, they can be terminated at will. So there really is no hearing or no termination hearing that they're entitled to. They can file a formal grievance. I'll get into that a little bit more in the next part, but there's no employment hearing at all. There's also the possibility of reporting them to the State Board for Educator Certification if there's some type of inappropriate conduct. That really only applies to those associate members with a certificate. So if you're an instructional aide and have a certificate with SBEC, you can be reported to them for some type of inappropriate activity or misconduct at work. If you do not have a certificate, there's a fairly new sort of do not hire registry that TEA has. So they investigate similar to how they would investigate a certificate. And they can put you on a do not hire list if you are found to have engaged in some type of inappropriate conduct. So that's more like a search. If you look up the do not hire list and you enter in a name, it'll either come up that they're under investigation, so that means there's a pending investigation going on, or they're not eligible for hire, which is, they can't be hired. And then no records match. So if you don't have a records matching, that means that you can be hired. You're not on that do not hire list. But just something to be aware of for those out there, either with a certificate or without a certificate. It does apply to associate members as well.
You mentioned grievances. What remedies might associate members have?
Yeah, the grievance is a district process that any employee can go through. So an associate member, if they have an employment concern, regarding their working conditions, or regarding anything that happened to them, like a reassignment or a bad evaluation, or if they get some type of reprimand that they don't agree with, they have the right to file a formal grievance. That applies to terminations as well. So that would be their main remedy for challenging a termination. That's something that we can certainly help with. We have grievance attorneys that handle those types of things. And it is a real case-by-case basis. The one major thing to be aware of with the grievance is how short the deadlines are. So an employee would typically only have 10 or 15 days after they learn about the incident to contact us or to file the grievance. So contacting us earlier than that would be advisable. So the grievance is a really good right that they have to bring up these types of concerns and complaints. If it's a discrimination issue where they feel like they're being discriminated against because of their age or their race or national origin or color, there is a slightly different process, but they can go through that process. We can help them with that process and try to work with them to come to agreement with the district on that. Finally, because they're at will, and this might sound a little bit negative, but they can actually resign without any kind of penalty. A teacher has a contract, and so they are locked into sort of a 1-year service with the district. An at-will employee, if they don't like their working conditions or don't like their supervisor or don't like how things are going at work, they have the right to resign without any kind of penalty to any certificate that they might have. It is standard in I guess the workplace to give 2 weeks of notice. But that's not even required by law. So that really allows an associate member to take matters into their own hands if things are sort of to the point where they don't feel like they can work for that district anymore. I kind of look at it as sort of a last resort, but that is an option that a lot of employees like teachers just simply don't have.
Is there anything else that associate members need to know?
It is important that we covered a lot of these issues, that if they have questions about these issues, they know that they can contact us. We can go through these issues in more detail, talk to them about their rights and options and whether or not they have any kind of legal claim, and really just kind of talk them through the process. So yeah, that they have the same right to contact us as any other school district employee, and we can certainly help them with any legal issue that they might have.
Lance, thank you for joining us today, and thank you for providing all this valuable information. As always, if you have any questions or feedback, you can send those to comm@atpe.org. That's COMM@atpe.org. And we encourage you to subscribe to the podcast and leave us a review. Thanks again for being here, and we'll see you next time on the ATPE Podcast.
Thanks for listening to the ATPE Podcast. For more information about becoming part of Texas's largest community of educators, please visit atpe.org. The information provided in this podcast is for general purposes only. Individual legal situations vary greatly, and viewers needing individual legal advice should consult directly with an attorney. Eligible ATPE members may contact the ATPE Member Legal Services Department.